Hello and welcome to the Elements of Deep Sea Mining. My name is Eric Young. Joining me today is Coalter Lathrop, an expert litigator and lecturer on topics related to the international law of the sea. Coalter is very concerned about the direction the United States government might take should they sanction recovery of mineral resources from the international seabed outside of the United Nations Convention on the Law of the Sea. I asked Coalter on to walk me through some of the risks and the context and history of international maritime law.
And now we have competing claims under different legal regimes to apparently quite valuable resources, and that's how wars start. So that's a danger that I'm worried about. I don't think it's science fiction. I don't think it's alarmist. I think it's a very real progression that could unfold over the years to come, and not many of them. And so that concerns me. And it goes to the rule of law.
As with anything, this topic has multiple perspectives. There are people who have praised the recent developments as well as those who have condemned. I'm interested in having someone on to talk in support of this alternative approach. I've reached out to the metals company, but if any listeners have suggestions for possible guests, please get in touch with me, eric@elementspod.com. Without further ado, my conversation with Coalter Lathrop. Coalter, thanks for being here.
Thanks, Eric.
Yeah, so I guess I want to start with you telling the listener with a very short attention span what your main message is. What are you here to communicate?
The elevator pitch on this for me is that irrespective of the environmental, economic, political, security considerations around deep seabed mining, that the U.S. approach at the moment of unilateral permitting in areas beyond national jurisdiction is not the correct approach. That's the main message. It's not the correct approach because it's unlawful, first and foremost, and as such, it threatens our system of international ocean governance. And from what I can tell, and I'm not a mining expert by any stretch, but it seems to be completely unnecessary as of right now. So the way of putting that last point is that deep seabed mining, a la the metals company under a U.S. permit in areas beyond national jurisdiction for polymetallic nodules, is a solution to a problem that doesn't exist. That would be my short answer.
Great. Well, then, before we get too deep into that, let's start with who you are and what expertise you bring to the topic.
Sure. My background is in ocean policy and international law. I've been in this field of scholarship and practice for over 3 decades now, pushing right around 30 years. My main focus in my academic side of my world is the law of the sea. Generally, I teach the law of the sea, the international law of the sea. And in my practice, I litigate mostly maritime boundaries between countries.
Where do you teach?
Well, I teach wherever somebody wants me to teach. So I teach a semi-regular course at Duke University's School of Law, sort of on an every other year basis. And I've been teaching in Korea every year for the last few years at their Law of the Sea Academy. I'm lecturing in Leiden in a week at their law school.
Beautiful. The practice side, so you represent nation states in border disputes, in maritime border disputes. I wonder, can you give an example of where a border dispute might arise so people can wrap their heads around that?
Where a border dispute might arise in the future. There's still some out there that are undelimited.
Well, I guess I was thinking where they have arisen, but yeah, just for those of us who assume that maps are fixed.
Yeah. Well, they're not. They're ever changing. I mean, anywhere there's a coastal state or a country with a coastline that has a neighbor anywhere nearby, whether it's an opposite neighbor or, an adjacent neighbor, they're going to have most likely some sort of overlapping claim to continental shelf and exclusive economic zone and maybe even territorial sea closer into shore. And that overlapping area will need to be either shared under some sort of joint management system that's relatively rare, or divided with a line. And so every coast of every continent, with the exception of Antarctica for now, has maritime boundaries protruding offshore.
But I mean, haven't those just been established for centuries? Why do they need you to come in and defend things at this point in history?
Yeah, well, they have not been established for centuries. I mean, land boundaries in a lot of cases have been in place and disrupted and reestablished for centuries, but maritime boundaries have not been, for the reason that there were no coastal state exclusive rights to maritime areas until relatively recently, with the exception of a very narrow marginal sea, what's now called the territorial sea, which for many decades was no broader, no wider than 3 nautical miles. So it was a very small area of ocean that would need to be delimited between two states. So there are some ancient agreements around these territorial sea delimitations, but they're quite small and short in comparison with the lines that are now required to delimit areas out to at least 200 nautical miles from shore. So it's a relatively new, second half of the 20th century sort of issue. In fact, the first case that arose was decided in 1969. So it's a pretty new field, really. It's just one of many sort of neighborly disputes, and they haven't gotten to it because it hasn't been important. Of course, the minute that a valuable resource is discovered or suspected to be in the area, then the urgency levels start to rise. So it's still a relatively new area of international relations in the grand scheme of things, and we're at about over 50% of the potential boundaries have been delimited.
That's not as many as I would have thought. Okay, so
maybe 60%.
So this explains why you have an interest in some aspects that would be relevant to deep sea mining. But yeah, so then what's your background kind of in the deep sea mining question, and what has caused you to take an interest in it?
Well, my interest generally comes from the law of the sea, and specifically from the United Nations Convention on the Law of the Sea, which was adopted in 1982, entered into force in 94. And within that convention or treaty, there are parts, and part 11 addresses the deep seabed mineral resources in areas beyond national jurisdiction. And what I'm concerned about, and what I think we'll be talking about, is limited to that area, by and large, that area beyond the exclusive jurisdiction of any coastal state. In the parlance of the law of the sea, the capital A area, the area. So that deep seabed mining, the area, the international legal regime that governs the area and its resources is all part of the law of the sea. So it's been in the background of my sort of area of interest, but I've never focused on it because there's a set of rules in place that are pretty clear, and it's been going along functioning as intended until very recently in March, April, when, for me, out of nowhere, the metals company announces that it's going to seek a U.S. permit under a 1980 statute called the Deep Seabed Hard Mineral Resources Act. And then rumors start to circulate about an executive order coming out of the White House, which then lands at the end of April. And that, for me, was sort of a, whoa, moment of what the heck is happening here? And I turned to it and have been looking at it and talking about it and writing about it since then, but that was just, early April.
So full disclosure wise, you don't have any interest in deep sea mining. This is for you just a kind of a professional issue that cropped up inside your field of expertise, and you have a concern about it, and that has kind of caused you to devote so much attention to it recently.
Well, I have no financial interest in deep seabed mining.
That's what I mean, yeah.
Yeah. I don't start. Maybe I have something in some mutual fund, but I don't have any TMC stock or any competitor stock. So I don't have a financial interest in deep seabed mining. I have a personal conviction that the rule of law is worth defending against what has been described by a couple of retired U.S. military commanders in a recent Newsweek op-ed, and I'm just quoting them here. I'm trying to defend against what they say is an initiative that is best understood as a speculative venture propped up by the shifting political winds, namely TMC's bid to mine under a U.S. permit. So now, professionally, it's been a really interesting topic. Haven't made a dime yet, but it's been very interesting and worthy of written comment and I think sort of my scholarly attention as well as my attention as a litigator.
Is this something in terms of law of the seas? This is a bit more newsworthy, a bit more. There's more public attention to this than other topics, or is it just my bubble that thinks that this is suddenly world news in terms of maritime law, but actually things like this are kind of continually happening, and to you this is kind of just one of many?
No, I think you're right. I think this is a hot topic right now for a number of reasons. For me, it became a hot topic because I'm an American and my current administration is threatening to violate the rule of law in an area that I pay a lot of attention to. And so it's become a hot topic for me, but it is sort of the hot topic in the law of the sea. And as compared to what I usually do, which is, assist countries in developing litigation strategy or work with them on negotiating a solution to their maritime boundary, which is very much a bilateral, relatively private process that is not of great public interest beyond the borders of those competing states, and that is not super timely or urgent in any way. I just finished up a case that really started in 1900, so it's not like this is something that everybody's paying a lot of attention to. So that is my typical bread and butter work with state clients. But so this is very different for me personally as well, to be in a mix that is, has currency and is important in the moment. Why I've never been on a podcast before.
Well, okay, so then I want you to lay out the kind of bullet points of your concerns, but I guess before we get off the topic of why this is newsworthy and significant, so the metals company announced their interest in taking a United States route to mining in the area as opposed to an International Seabed Authority route back in March. Mm-hmm. And that was the kind of first I'd heard of that being a possibility. And then, I've since learned that this regulation that they applied under has been on the books since the 80s. And indeed, there's been exploration licenses granted under this for a long time. So what makes this kind of recent development different from the 6 or 8 times that this has happened before in the last 50 years?
This being,
why is
license granted under?
Why is TMC's application different than the licenses that Lockheed Martin hold?
I think there's 2 big differences. One is that TMC is applying for a commercial recovery permit, which would, if it were granted under DSHMRA, which is the awkward acronym of the Deep Seabed Hard Mineral Resources Act, would be the first of its kind, mm-hmm. which they tout on a regular basis. So that's one. Lockheed Martin has held exploration licenses, but nobody has ever been granted or even, as far as I know, requested or applied for a commercial recovery permit. The other reason that they're different is basically timing in history. DSHMRA was enacted 1980 as an interim measure pending the completion of an international treaty that would regulate mining in the area. And that treaty has since been negotiated and then, at the request of the United States, renegotiated and has been in place and operating now since 1994. And here I'm referring to the 1994 implementing agreement for Part 11, which basically reworked a lot of the aspects of the deep seabed mining regime under the initial UN Convention on the Law of the Sea in order to assuage the United States and accommodate its demands, essentially. That implementing agreement was completed in 1994 and has been operating now for over 30 years. So those dates are important because Lockheed and Company received their DSHMRA exploration permits in 1984 under DSHMRA, before the Law of the Sea Convention entered into force, and certainly before the implementing agreement altering in favor of the United States Part 11 was even done being negotiated, much less entered into force. No permit or license has been issued since 1984. Two of the four have been surrendered. So there's only two active exploration licenses held by Lockheed right now. I think what you're referring to and what a lot of other folks are referring to when they say DSHMRA has been active for the last, since 1980, is the basically pro forma rubber stamp extension of the licenses, which is something that NOAA, the National Oceanic and Atmospheric Administration, which is the agency tasked with issuing DSHMRA licenses, must do. It's a shall do as long as the applicant for the extension has satisfied some pretty low hurdles, which Lockheed has managed to do. So DSHMRA hasn't been active in any real sense since 1984. And 10 years after 1984, the International Seabed Authority and the international governance regime of resources in the area was put in place. And the United States participated and has participated actively in that regime since then. So for this announcement on March 27th or 28th to come out of TMC was very new.
Yeah, wasn't the same thing.
Very new and very different from Lockheed Martin's approach. Lockheed Martin's approach was, yes, we hold these exploration licenses, but we can't use them because there's a legal regime in place, and these are outside that legal regime. And so if we go act on these licenses issued by one of 190-something countries in the world to exploit a resource that's governed by international law, we will have no security of tenure. It means nothing outside of the United States.
Yeah, I hadn't thought of this way before. It didn't click for me that those existing permits kind of predated 1994. But the more I learn about this, the more it seems like DSHMRA kind of, and we'll talk about this later, but DSHMRA kind of parallels UNCLOS to some degree and leaves open the possibility of a future kind of merger of two independent regimes. So if Lockheed Martin is sitting on some licenses under DSHMRA, perhaps when the United States gets around, if the United States gets around to ratifying UNCLOS, then Lockheed Martin can hope that those just kind of get transferred as is to that international regime. And that's one, certainly, I don't know if you agree that that's one possible way of kind of seeing that.
That's absolutely the way to see it. Lockheed Martin is sitting on licenses that will be grandfathered into the ISA system once and if ever the United States decides to join the convention that it crafted over the course of decades to its advantage. So yes, Lockheed, at least Lockheed pre-March of this year, was of the mind that we cannot exercise these licenses lawfully, and we will not do so.
And there was
And that may be changing, by the way. I'm trying to keep tabs a little bit on what Lockheed is up to these days, but that's been their line since the mid 80s.
Yeah, and I've also seen in some of the statements put out by NOAA on this, some language around that has also been NOAA's line, that these kind of any rights that are granted by NOAA are only granted as kind of as it would pertain to other US entities interested in the same thing, and that they wouldn't have anything to say against other international entities.
That's exactly right.
And I assume that those Lockheed Martin licenses don't conflict with anything that ISA. I mean, I don't know this. I don't know where those licenses are, but I assume that the ISA hasn't given away that bit of geography to anybody else.
They have not given away those two big bits of geography to anyone else. And if you look at the ISA maps of the Clarion-Clipperton zone, there's a couple of big open areas, and those are USA 1 and USA 4, and they are waiting for Lockheed or whoever is holding those permits to come and engage in the ISA processes. So that's how this, sort of maybe uncomfortable relationship between a non-party state like the United States, who has a law on its books from 1980 that was implemented as an interim measure anticipating the completion of a treaty, and the U.S. accession to that treaty, the first of which has happened, the second which has not. How does that live with this very real and alive international regime embodied in the International Seabed Authority sitting in Kingston, Jamaica? The way that it's worked until April is that the United States has maintained observer status, participated actively in discussions, doesn't have a vote, of course, can't take its guaranteed seat on the council, and can't exercise its leadership role in that forum because we're not a party to the treaty. But nonetheless, until, again, very, very recently, the United States has been an active participant in the process to the extent that it can as an observer state, and the holder of U.S. Licenses under DSHMRA has been sitting, waiting in the wings, advocating for ratification, and presumably hoping that someday they would be able to exercise their rights under international law, not outside of international law. And you're right that NOAA has said, we grant this extension to you, Lockheed Martin, but just be clear, to paraphrase, this doesn't guarantee you diddly squat out in the real world. The only entity that you can wave this piece of paper in front of is another U.S. citizen applying for a DSHMRA license or permit. Other than that, it's worth nothing. And NOAA has said that quite clearly. And Lockheed Martin has said, we are not going to risk the millions of dollars that it's going to take to start this industry on the basis of this scrap of paper.
And then I guess before we close on what's significant about this, what about the executive order? So one thing is that this is the first kind of application since 1994. Another thing is that it's also an application for exploitation, but then the U.S. administration released an executive order. And so what impact does that have on this?
Well, a couple of things about that executive order. One, which is important, and I think it might help your listenership to understand that executive order was not just about exploitation in areas beyond national jurisdiction. In fact, it was almost not about that at all. It was primarily about permitting within U.S. jurisdiction. And in both cases, it was essentially calling for an acceleration of the process. So not creating new processes or new laws or anything like that, but just calling for the agencies in the executive branch to pick up the pace, essentially. That executive order, as a matter of law, has very little force, but what it does do is it signals to, in this case, industry, that the White House is behind you. Yes. Now, I wasn't in the halls of the White House, but my understanding is that TMC lobbied very, very hard for those lines in the executive order, which invoke DSHMRA and bring NOAA into the picture. So, the effect of the executive order is it's a very clear statement of purpose on behalf of the executive branch of the United States government. And it has, sort of working hand in glove with TMC, it's prompted TMC to submit applications for 2 exploration licenses and 1 commercial recovery permit.
Okay, so then I'm really interested in having you give context and background on all of this, all of the international law of the sea aspects here. But before that, so you've written a few pieces criticizing these recent developments, and I guess I want you to kind of give a short summary of what your main concerns are of these recent developments.
Main concerns are that this, if it were to go forward, would undermine the rule of law in the oceans. We've got at the moment in the United States, we're seeing a lot of challenges to the rule of law in the domestic sphere, but also in the international sphere. And so this is just one of those challenges to the rule of law. And, in and of itself, it won't be a fatal blow, but it would cause erosion at a minimum to a system that, again, the United States was instrumental in creating for its own benefit. I mean, the United States benefits more than any other country in the world from this international set of rules that I'm talking about. So partly there's the potential for a major self-inflicted wound, but just in principle, I, as an attorney, am sworn to uphold the rule of law. So I have a professional obligation to some degree to be concerned about and push back against this, what I see as a threat. So that's my main concern.
Yeah, on that, I mean, listeners to this podcast have heard me say this a number of times, but I hear some people smarter than me talk about how technological developments, as well as just kind of general direction that the world is going, climate change, multipolarity, AI, are all things that require more international government, more international cooperation. And so I'm also concerned about things that kind of decrease the ease of flow of international cooperation. Anything that threatens international laws seems to me a bit risky given our current place in history.
Yeah, well, I agree. I mean, I think, it's like a Jenga tower, and right now the U.S. administration is pulling pieces out. And this is one of those pieces. Hope your listeners know what a Jenga tower is.
I hope everybody has had the pleasure of a Jenga tower.
Yeah, look it up. So, yeah, that's my main concern. I mean, if you ask me about my concern, that's the main concern. My writing and speaking has been motivated by that concern.
Okay. Well, then, I'm a bit wondering if we should get into more of the specific risks, or if we should jump farther back into the history and talk about, because I think people are interested in understanding what the heck UNCLOS is and why it's significant, and especially how it came about.
Well, I'm happy to get into that, and I'll try to keep it brief, sort of intro to the law of the sea. But one thing that is sort of fundamental to the law of the sea is these different jurisdictional zones that have been created over the decades by the multilateral negotiating process, also by sort of unilateral actions by certain coastal states. But the way that geography stands today is that a coastal state, a state with a coast, a country with a coast, can claim and enjoy sovereignty over a 12 nautical mile territorial sea. That's the distance to seaward measured from the shore. And within that territorial sea, a country is basically sovereign as it is on land, has complete jurisdiction and control over all activities and legislating and enforcing in that area, with the exception of innocent passage, which is this idea that vessels flagged by a different country are allowed, including military vessels, to transit through the territorial sea. The next, we're going to skip the contiguous zone. That's another zone. The next important zone to seaward is the exclusive economic zone, which can be measured as far as 200 nautical miles from that same coast that you measured the territorial sea from. And as the name would suggest, in that zone, which includes the water column and the seabed and subsoil, but not the airspace, the coastal state has exclusive sovereign rights over the economic resources and activities in that area, fishing, oil and gas. Beyond that, in some cases, geographically speaking, from the coast, although earlier in time in the history of the development of the law of the sea, is the continental shelf, which under certain geomorphological and geological circumstances can extend quite a ways farther out than 200 nautical miles. So it can extend beyond the outer limit of the exclusive economic zone. And where that set of sort of physical circumstances exist, the coastal state enjoys sovereign rights over the seabed and subsoil of that area beyond 200 nautical miles, but not the superadjacent waters, right? So we're talking at that point natural resources of the seabed and subsoil, which by and large is mineral resources. That continental shelf has an outer limit, and beyond that outer limit of all of the coastal states of the world is the so-called area. That's the international seabed, and that is not available as a matter of exclusive right to any coastal state. That's the area that we're talking about here that's governed by Part 11, the 1994 Implementing Agreement, and the International Seabed Authority. So that's where we stand today. In 1945, at the very end, like 80 years ago, more or less today, the geography of the international of the oceans of the world was very different, because it really consisted of two zones. One was a territorial sea of some as yet undefined breadth. 3 nautical miles, 12 nautical miles were sort of the contenders. And beyond that was the high seas, where the freedom of the high seas, the regime of the freedom of the high seas was in place. Freedom to fish, any nation could fish. Freedom to navigate, any nation could navigate or fly over these areas. Freedom to lay submarine cables and pipelines. In 1945, 80 years ago, President Truman issued a proclamation that accompanied an executive order. So here we have a parallel from 80 years ago of a unilateral action by the executive branch of the United States of America, claiming the continental shelf, areas of shallow seabed off the coasts of America, in the Gulf of Mexico, in the Atlantic, in the Arctic, in the Pacific, wherever a continental shelf, a physical continental shelf existed. By 1958, that was the codified international law, codified in a treaty. By 1969, the International Court of Justice was saying that this right to the continental shelf was an inherent right that existed ab initio and ipso facto. So you had this 20-year period or so where, triggered by unilateral U.S. proclamation, we now have a completely different regime governing at least the seabed. At that point, we still don't know how broad the territorial sea is. The exclusive economic zone hasn't even been imagined. But we have these extensive areas of seabed that are now for the coastal states' exclusive use. What happens beyond that seabed, the continental shelf, the exclusive part of the seabed, really hasn't been considered. In the 50s, the International Law Commission, which is the UN agency that drafts a lot of this sort of draft treaty language, said we're not considering it because it's not really an issue, because economically and technologically it wasn't an issue.
Yeah.
But it would require some regulation of some kind at some point in the future. So that's where we sort of stood in the 50s and 60s.
I think that's interesting to think about in terms of what was happening in the 50s and 60s. So oil had kind of become an important thing in the beginning of the 19th century. Before that, it wasn't really that important a resource. It became super important in the interwar period and in World War II. And I assume around the time that Truman realizes that the US wants to have exclusive control over any oil that happens to be sitting on its continental shelf, coincides with some realization that there's oil there and some development of technology to get that. So this is the kind of geopolitically important resource of the day that is technologically becoming kind of available. And so now the regulations have to catch up to the reality, and they're being driven by people with an interest in those things. I think that that's an interesting parallel to kind of lay out for the current situation.
I really couldn't have said it better, and you're absolutely right. You're absolutely right. In 1943, we're in the middle of World War II, and the United States is supplying a lot of the fuel, jet fuel, petroleum products to fuel the war effort. And there's a real concern that we're running low, and that if we had a next conflict, we wouldn't have access. And in 1943, the Secretary of the Interior turns to Roosevelt, still president, and says, I want to direct your attention to the continental shelf as a potential treasure trove of natural resources. And in particular, they were looking at the Gulf of Mexico, which has a broad shelf, which they were starting to speculate may contain continuations of the strata that we find in Louisiana and Texas, which had already been exploited by then for some 40 years. And the concern that Harold Ickes had, the Secretary of the Interior, was, and he related this to President Roosevelt, is that if we were to claim this, we would need to develop a new theory of international law as to why it would be ours. Because the prevailing law at the time was that the freedom of the high seas was in place for areas beyond 3 nautical miles. And a foreign entity could come in and capture that resource under a rule of capture of a res nullius, or a thing owned by no one. And Roosevelt articulated that concern, saying essentially, we need to develop a common sense rule, those were his words, that would prevent some European nation from coming in and drilling in the Gulf right off of our coast. And so 2 years later, that was in June of 43, 2 years later, the proclamation was issued by his successor, Harry Truman, and the rest, as they say, is history. So, and in terms of who was behind the making of this law, it's an interesting little deep dive into the process of lawmaking, international lawmaking, that followed Truman's proclamation. The very first report that we have on the international scene comes out of the International Law Association in 1948. It's drafted by a Dutch lawyer who nobody's ever heard of and nobody will ever hear from again. And he puts down on paper the reason that we should all basically adopt Truman's proclamation, or this approach that the coastal state gets the seabed off of its shore. Who the heck is this guy? Spice. Peter Rutger Spice. He's a legal advisor for Royal Dutch Shell. So, yeah, the parallels are fairly strong. Corporate interest, in a resource, driving and reshaping or making international law. So I worry that we're at the beginning of that process again. There it was a remaking of the rule with a common sense rule, Roosevelt's words, from a somewhat inchoate idea that anybody who wanted to could come and fish, for oil off of your coast, just like you can fish for fish off of your coast. Proclamation in 45 displaced an existing rule. Here, we have a really well-established set of rules that the United States is trying to roll back.
I guess the other theme there that occurs to me while you're talking is just kind of the interest that everyone has in having clear rules. So it's one thing to look at this through the United States needs oil and happens to have a lot of continental shelf, so it's in their interest to draft a rule that says, hey, we get to have unilateral control of minerals on our shelf. But also, it's just kind of, well, I mean, I guess this is a little bit the common sense aspect is maybe if there's going to be the next important resource and it's all over the place within kind of 100 miles of people's sovereign territory, maybe it would just decrease the risk of conflict if we could assign a kind of rights to that, and then people can negotiate over those rights and we can fit it into a working legal regime.
You would have, Scythe would have enjoyed that intervention. And so there were two existing and competing ideas pre-Truman Proclamation. One was this idea of a res nullius. Anybody could come in and take it if they got there first, if they had the technological capability to do so. And we can sort of imagine who the winners and losers would be on that. And the argument against that was rule of the jungle, or the rush and grab was the terminology of the day. We're concerned about the rush and grab. So yes, they envisioned chaos, and certainly that's not unrealistic. There was another theory in place, which was much more in keeping with the overall mare liberum Roshan concept of open and free seas. These are common spaces owned by no one and everyone. And the Latin on that one is res communis. So this is the idea that no individual corporate entity or country can capture these resources without the approval and oversight of the international community. This was being voiced largely in the French school, for lack of a better word, while the British were a little bit more on the res nullius end of things. And in fact, the legal advisor in the Foreign Office in 1923, Cecil Hurst, fleshed out the res nullius theory. So that was more of the British school. But the French school was leaning more towards this is everybody's and no one's. And therefore, it should be internationalized.
Kind of makes sense in terms of British common law's preference for dealing with things through contracts and at least in my head, the French preference for a centralized codified rule.
There was that, but I'll throw in the corporate interest here as well, because in the 1920s, the debate was not about polymetallic nodules or oil fields buried in the subsoil of the seabed off of your coast. The debate was about pearl fisheries off of Ceylon, Sri Lanka, or Western Australia, and claims by the British to exclusive jurisdiction over those natural resources, despite the fact that they were well beyond the territorial sea. And so Hearst was, without being express about it, he was basically defending and supporting the British position that, yes, in fact, we can own by occupation and use these natural resources in areas that would otherwise be considered high seas and available to everyone. So we have pearls, oil, and polymetallic nodules. We can do something better. Pearls, petroleum, and polymetallic nodules. How about that? And that's a story that goes over 100 years now of resource-driven lawmaking.
Yeah. Fascinating. Okay, so then if you don't mind, take us from there to the kind of the next step of UNCLOS. So what we're talking about is how it came to pass that countries got to have kind of sovereign control over mineral resources in certain areas, but there's still the area beyond national jurisdictions. And I think you've got like a slightly different take on the drivers behind what caused countries to come together and make UNCLOS than I'd heard before. Previously, I'd kind of heard, well, there's this message of abundance. There's so many minerals out there, and there's going to be nothing but kind of good things, and so let's get together and benefit from this. But I think in your writing, I heard more of kind of a scarcity narrative driving that.
You know, in 58, we had the codification of essentially Truman's proclamation relative to the continental shelf, so that coastal states get exclusive jurisdiction over the natural resources of the seabed out to, in 58, one of two outer limits. The first was a depth criterion, 200 meters, which was sort of the conventional shorthand for the edge of the shelf and the beginning of the slope as a matter of physical oceanography. So the coastal state had exclusive jurisdiction out to the 200-meter depth line, or to the depth of exploitation, which of course is moving seaward with technology on a daily basis. And theoretically, moving across the entire ocean. If we applied that criterion today, every coastal state's exclusive rights would dominate the entire ocean geography. In 1967, the Maltese ambassador to the United Nations, Arvid Pardo, brought this potential problem to the attention of the international community and basically said, we should think about preserving an area of the seabed from exclusive jurisdiction for the purposes of the international community. Echoes of res communis. And that discussion in the UN General Assembly kicked off the formation of the Seabed Committee in the late 60s, whose job it was to figure out how the exclusive continental shelf of coastal states was going to interact with whatever was happening beyond that, and then what was happening beyond that, what rules should we put into place about both the distance or the criteria by which we're going to limit coastal state jurisdiction, geographically speaking, on the one hand, and on the other, once we do that, we have what's now called the area to consider, and what's the governance structure for that area. So those were the two main considerations of the Seabed Committee in the late 60s, which morphed into, by 1973, the UN Convention on the Law of the Sea conference, the third UN conference on the law of the sea. The first was in 58, where we got the 1958 conventions on the seas, territorial sea and contiguous zone, fishing, and continental shelf. The second was an attempt in 1960. All they wanted to try to do was agree on the breadth of the territorial sea, and it failed. So the third UN conference on the law of the sea was convened in 73 and went through 82, and the product of that conference was the UN Convention on the Law of the Sea. But it started with the concern voiced by Pardo in 67 that if the exploitation criterion of the 1958 convention was allowed to take its natural course, then all of the seabed of the world would be under the exclusive jurisdiction of one or another coastal state. Or two, if we left it in the realm of the res nullius rule of capture, then only the most technologically advanced countries in the world would benefit, because Malta doesn't have the ability to go out and gather these nodules, which we've known about as a species since the late 1800s. Ironically, Malta is the flag state of the hidden gem, and Arvid Pardo would absolutely be rolling in his grave if that vessel is used in the way that all seas and TMC intend for it to be used. But that's an aside. So this is all just to say that it was, in fact, deep seabed hard mineral resources that drove from the late 60s the concerns that then turned into the conference that then created the law of the sea convention.
Yeah, and concerns over kind of might is right being the dominating principle for what would happen if we don't if we don't have international law, then it kind of defaults to the law of the
Exactly.
jungle.
And look where we are now.
Well, great. Then, I don't know if you've got other directions you'd like to go. I mean, I want to hear how dangerous this is. How dangerous is the potential unilateral action by USA in the area in the context of international norms and laws? If you can put that into context, and I think a lot of people who are kind of aware of deep sea mining might not be aware of other geopolitical issues, other tensions, other things that international law is doing, especially in maritime situations that are kind of important and currently topical and currently laden with risk. So take that in whatever direction you'd like to.
Danger. I mean, there's the danger to the system of ocean governance that we, as a group of states, have developed over the decades. That's to me the real threat. And so the danger to the U.S. in that context comes from the notion that the law of the sea is a package deal. A lot of deals were cut between the various interests and actors over the course of these decades of negotiation. Just to go back to the seabed, which is really where all this is happening. For example, coastal states with a wide margin shelf, like the United States, wanted a rule in place that would allow them to extend their exclusive jurisdiction as far seaward as possible. Coastal states with a narrow margin shelf, like Chile and Peru, Ecuador, all of the western side of the South American continent, would benefit zero from such a rule. And so they were pushing back in other directions. You know, the Malta example and the example of the global South that is saying essentially, we want a rule that protects our interests in all of these hard mineral resources that we understand may exist on the seafloor outside of the continental shelf. So we want a set of rules that protect our interests there. And together, those 160 or so states, or however many negotiating states there were at the time, and it was an increasing number over the course of the decade that it took to negotiate this treaty, came to an agreement called the UN Convention on the Law of the Sea, which is a package deal. We'll give you that, but we get this, and vice versa. And one of the fundamental components of that package deal, as you may have guessed, considering how this all started, was the rules governing the resources of the deep seabed. And so if you then take that part of the Jenga tower out, and yet you rely on the rest of the package deal to claim, in the case of the United States, 11 million square kilometers of exclusive economic zone and another million square kilometers of continental shelf beyond that exclusive economic zone, you may be undermining your own case. If you rely on that treaty to drive your warships through Chinese claimed territorial sea around disputed islands and then take out the Jenga block of the ISA and the international seabed regime, you may be undermining your position. So
yeah, say
that
more about that
kind of thing.
Because I think say a little bit more about that because I think a lot of us can wrap our minds around like, okay, yeah, there's a danger in the international rules, laws, and norms breaking down, being undermined by people kind of losing trust or seeing that, okay, if the United States doesn't have to play by these rules, then we don't have to either. But a lot of us can't visualize what a breakdown of these rules would look like. So I sometimes see news articles saying that there's something going on little coral atolls in the South China Sea. There's fishing ships being shot with water cannons. And I assume that this has to do with the kind of thing that international maritime law is there to kind of enforce. So I wonder if you can just put more color to that.
Yeah, what you see happening in the South China Sea is largely a function of China making a large and, as adjudged by a tribunal, unlawful claim to areas of the South China Sea that have no basis in international law. The United States has come in as a bit of a scold on that. I think it's justifiable. I agree with this particular South China Sea Arbitration Tribunal's award and decision around China's claims. But when you're not a party to the treaty that governs a lot of this, as we are not, the United States, you lose some moral authority. And China says this all the time. Like, don't talk to us about the laws of the sea if you're not going to become a party to the convention that governs the sea. So that was already a little bit of a problem, sort of our moral authority to lead in maritime governance and to push for the for following and enforcement of the rules of law that govern the oceans. But now add to that this assault on one of the keystone rules, that is the assault through potential U.S. unilateral permitting of exploitation of mineral resources in the international seabed, and you undermine it even further. And suddenly we're no longer the moral authority, we're the rogue element. And that's not where I think the U.S. wants to be in the international scene, and yet that's where we're headed. So that's a danger. If you want to talk about sort of more like death and destruction danger or real conflict that might arise between naval forces, if CMC, under a U.S. permit, were to go out on the Hidden Gem into the Clarion-Clipperton Zone to exploit, to lift polymetallic nodules off the international seabed in violation of international law, in violation of an international treaty to which China and Russia and India and Japan and Korea and fill in every other coastal state in the world, with a few exceptions, those states, and in particular those states that have a direct interest in the international seabed because they are holding licenses to exploit those areas, I think we will see naval vessels from another country appear on the horizon. Now, does that turn into a shooting war in the moment? Obviously, I hope not. But the interests are such that it's possible.
And this is the kind of thing that sort of happens occasionally. I mean, this is where I think I see the news articles about water cannons being shot at. So there's kind of ways of haggling over these maritime issues without kind of devolving into an actual open armed conflict. But you can get out there and you see these countries posturing and driving warships through places to send messages about how close you can come to breaching various lines.
And if the U.S. was serious, it would have its own warships in the area. And now we have competing claims under different legal regimes to apparently quite valuable resources, and that's how wars start. That's a danger that I'm worried about. I don't think it's science fiction. I don't think it's alarmist. I think it's a very real progression that could unfold over the years to come, and not many of them, a couple of years. And so that concerns me. And it goes to the rule of law. It's a rule, it's based in the violation of a rule of law. And here we suddenly have this flip where currently the U.S. Navy does freedom of navigation operations throughout the South China Sea, and we lawfully drive our warships through zones that other countries say you can't come in here, and we invoke innocent passage through the territorial sea, which is a law of the sea principle. And I think that we're legally in the right there. But it's a flip, right? Now, the U.S. would be driving its warships around the Pacific Ocean in order to protect unlawful resource grabs by corporate entities under its licenses. And other navies would appear on the horizon and say, no.
Okay, well, that's sufficiently worrisome and colorful, I hope, for listeners who
I mean, I hope it's not what I want to have happen. It's what I want to keep from happening. And I think that when you create this unnecessary tension is pushing us further down that road.
And then what about the legal side of UNCLOS and what its prerogative is in kind of regulating the international sea? So it's one thing for the United States to say, hey, we're going to make a conflicting regulation over somewhere that you already have regulations. And what avenues are there for international law to work here? How much teeth does UNCLOS have to enforce its regulations?
Well, part of the package deal that I referred to includes, I referred to Part 11. Part 11 of the convention addresses the deep seabed. Part 15, which is also in the package deal, is the dispute settlement provisions, which are binding on the states' parties. A substantive obligation in the convention is to, so if I'm a state party, like I'm the Netherlands or Switzerland, let's just say, state party to the convention, I'm bound by the rules of the convention. And so I look in the convention and I see these articles in Part 11, like 137 and 139. And I read closely 139 paragraph 1, and I say, oh, I have a duty as a party to this convention to ensure that my nationals don't participate in activities in the area in violation of this convention. That's my international law obligation under this treaty to which I'm a party. National in my territory called All Seas that is slated to participate in activities in the area outside of the convention. I have an international law obligation to ensure that that national All Seas does not participate in activities in the area outside of the convention. So I now have to either enact laws that would criminalize or in some way make unlawful All Seas participation in TMC's scheme, and then enforce that law against All Seas to prevent it from participating in activities in the area outside of the convention. That's a Dutch domestic legislative issue. Or else, possibly, I will face a lawsuit from a fellow state party to the convention. Probably one of the 38 states currently calling for a moratorium on deep seabed mining, 37 of whom are parties to the convention. Any one of those 37 states or any other state party to the convention, and there's 169 of them, including all of the industrialized states except Turkey and the United States. All of those countries have access to compulsory dispute settlement against, in this example, the Netherlands. So if you look down that list, you see a lot of countries who could invoke the dispute settlement provisions of the Law of the Sea Convention to sue the Netherlands for not ensuring that its nationals don't participate in activities in the area outside of the convention. And same for Switzerland, where All Seas is headquartered. Same for Japan, where PAMCO is presumably going to process some of the ill-gotten ore from TMC's lifts, or Indonesia. Canada, where TMC is headquartered. Malta, where the hidden gem is flagged. All of those states are potential respondent states to a claim against them under the Law of the Sea Convention. So that is where the teeth are in the convention. And it's an unusual set of teeth because most conventions have substantive rules like thou shalt not, but they don't have any dispute settlement provisions that have any teeth. And so the Netherlands says, buzz off, because I haven't consented to jurisdiction of any court or tribunal to hear this case. That's not the situation in the Law of the Sea Convention. Every state party, all 169 of them, have consented to the jurisdiction of, could be the ICJ, could be the International Tribunal for the Law of the Sea in Hamburg, Germany, could be an ad hoc tribunal formed in Annex 7 of the convention. But in any event, there is jurisdiction to sue states parties to the convention that violate their substantive obligations, such as 139.1, when they have allowed their nationals to participate in this unlawful mining.
Yeah, I guess that's always been my perception of international law, is that it's toothless, and this was a little bit why I was so concerned about the dissolution of norms, is that there isn't anything to there's no higher authority to appeal to. So it's interesting that in this case there are mechanisms that, although it sounds like there's a kind of a chain of mechanisms, you have to rely on the local government to kind of take the action, and then it's the place of other governments to put the pressure on the local government through tribunals and courts that have been established.
That's right. The Netherlands has an obligation at the international plane because it's a party to the treaty. It should, in an ideal world, incorporate those obligations into its domestic legal system by making it unlawful under Dutch law to participate in unlawful activities in the area, unlawful as a matter of international law. And then, ideally, the Dutch authorities should enforce their Dutch law against a Dutch national that's violating their law, which arises from their international obligations, but has been incorporated into their domestic law. Now, most states have not incorporated their international law of the sea obligations around seabed minerals into their domestic law. And they probably don't really intend to. And so that's where you go back up to the international plane and you get country A suing country B and invoking their international obligations to get them to do what they're supposed to be doing at the domestic level, which is implementing their international obligations and enforcing against their nationals. So it is definitely it's a multi-step for sure, but it is there. And it's there, again, somewhat uniquely in the Law of the Sea setting because Part 15 is integral. The dispute settlement part of the convention is integral to the convention. So if you're a part of the convention, you have already consented to the jurisdiction of the dispute settlement mechanisms embedded in Part 15. Most conventions, most international treaties tell you what the substantive rules are, but if you violate them, unless you've submitted to the jurisdiction of court X, Y, or Z, there's no way for country A to come after violator country B in a adjudicative setting.
This makes me wonder like any national of a country is bound to abide by the laws of that country, but if those laws aren't there on the books saying you actually can't go out and mine the deep sea outside of ISA rules, should a corporation have to look ahead to these international treaties and say, okay, well, I see that there's a treaty that my country is bound by that should then make it put a law which doesn't currently exist that I should then follow. There's a lot of steps of interpretation that corporations or actors are kind of expected to follow and guess. It sounds unideal.
Well, yeah. So again, in an ideal frictionless world, the Dutch parliament would draft and vote to enact a law implementing their international legal obligations, and then they would let all seas know that there's a new law in the books and that they're in violation. That's not how the world works. And so instead, what's happening in the Netherlands is that members of parliament are raising the question, and they're asking their ministers of environment and foreign affairs. We understand we have international legal obligations, and we've got a national that's, being listed in all of TMC's press releases and SEC filings as the operator and partner in this endeavor. What are we doing about that? So there are moves afoot at the national level. But generally speaking, the answer when I contact Japan or Switzerland or the Netherlands is, we can't do anything because we don't have any laws on our books. And I say, well, that's not going to get you out of your international law obligations, because that is expressly not, the fact that you haven't legislated at the national level is expressly not an excuse under the Vienna Convention on the Law of Treaties to shirk your treaty obligations. So those governments may find themselves in a bind. Those companies may find themselves somewhat surprised, although Allseas won't be, because this has been pretty well brought to their attention. AMCO maybe gets a rude awakening when the Japanese government finally gets around to saying, yeah, you cannot take possession of any of these metallic nodules gathered by TMC under a U.S. permit, because we, Japan, have an international legal obligation to prevent that from happening. Korea Zinc, ditto. Whoever the processor might end up being in Indonesia, ditto. In Canada, same thing. How are we supposed to enforce against TMC? We don't have any laws on our books. TMC is based in your country. You have a corporation in your territory. You are a party to the law of the Sea Convention. You have obligations under that convention. Figure it out.
We should also say TMC, Allseas, they haven't done anything that would violate any of that at this point. This is all what would happen should mining happen to commence under unilaterally United States.
That's absolutely right. And that's the answer that the Minister of Environment in the Netherlands gave to the member of parliament who asked the question. Well, it's not an issue yet. Let me take you back, if you'll indulge me. Let me take you back to 1948 and Peter Rutger Feith's reason given as to why res communis, internationalization of the continental shelf seabed resources, was not practical. It was because the United States had already said, these are ours. It was, in his words, essentially, it's impractical to think that the United States is going to put its newly acquired resources back in the pool. So I'm really worried that that same fact pattern will unfold here. Sort of cat's out of the bag, it's too late. So the idea that it's too early, which is what you're invoking, is concerning for me, because it's going to either be too early or too late. And so, and you can see this again in the Dutch parliament setting on Friday of last week, when a member of parliament submitted written questions to the Minister of Foreign Affairs, basically saying, I don't know if you're aware of the reporting, but apparently this thing's moving pretty fast. And so what are we doing about our national?
That it's too early until it's too late. I feel like that's not an optimistic stance, given the way that humanity tends to deal with crises on the horizon. Coulter, I see I've used up all of the scheduled time, so I don't know if you've got anything else you particularly want to touch on in terms of risks, in terms of messages about this that you want to cover before we move on to kind of my must-do questions.
Yeah, no, I think we've covered a lot of stuff. I'm happy to have been able to say a few things about the historical context. I hope that that's helpful for your listeners to sort of understand that this isn't like Gerard Barron came out of nowhere and thought, oh, wouldn't it be a great idea if we just went out and picked these things up and there's nothing that would be disrupted by doing so? Nothing, I'm not even talking about disturbances of the physical seabed. I'm talking about disruption of an existing and long-standing and well-developed set of rules. And I worry that, I mean, I don't think Barron is unaware of that, but I do worry that the current U.S. administration may be largely unaware of the sort of hazards that I'm pointing to here.
Well, I think historical context is extremely valuable, especially, I mean, I feel like we're learning this a lot in the context of American politics right now, is so many things are built on norms and expectations and history as opposed to rules that are written down that we could just do what it says in the regulation. So to me, the context is super important. So I try to ask everybody this somewhat awkward question about trade-offs because it relates to my PhD research, and I want to get it from you as a legal scholar who has to deal with negotiations, I guess, a lot. How do you how do people make decisions that involve balancing between trade-offs, especially across different value categories? If that's enough of a prompt, let me know if you need more.
Well, I don't think they do it very well. You know, I think in the context of the mineral resources of the deep seabed, including within national jurisdiction, so not just in the international area, but areas within national jurisdiction where my beef is not relevant, but the sort of environmental concerns, the security and economic concerns are still relevant there. So really thinking about it in terms of any form of seabed mining in any part of the oceans, the idea that we fly around in jets and are also opposed to drilling for fossil fuels, or the idea that we drive around in battery powered cars and are fundamentally opposed to the idea of extractive industries bringing cobalt and nickel into the supply chain, is one of those real weak points, I think, on the sort of, in the United States, the sort of coastal elite worldview. This idea that our iPhones just sort of materialized out of thin air, you know, is pervasive, I think. And so among a certain class of at least Americans, I think it probably spreads to other countries. And yet somewhere in the world, those resources were extracted and processed and turned into your or Rivian or, you know, other EV that you drive around quite proudly in and virtue signal about your environmental credentials. I mean, I'm guilty of it. So I'm, you know, I lean environmental. But if we can't acknowledge that somewhere somebody is digging and somewhere somebody is probably polluting rivers in the processing, and somewhere somebody's backyard has these extractive activities occurring in them, then we're just doing NIMBY. And I think in America, we've gotten so divorced from the extractive process and the processing process. We don't do it here anymore. It's not what we do, but we do consume the products. And so that's where I'm going with, I think we do a really bad job on trade-offs because we have not had to make them locally in our lives as, you know, relatively Americans or other, you know, citizens of other countries who get to consume the clean, finished product without regard to where the raw materials for that product came. You know, I think we do a bad job. That in and of itself doesn't justify a unilateral violation of a really important rule, in my view. But it should be part of the dialogue, and I don't think it is for the most part.
Let me ask another awkward and difficult question, and if it doesn't work, then I'll take the blame, as Tim Ferriss sometimes says. How do you draw the line between a legal and an ethical issue? Is there sometimes in your practice that you are confronted with issues that are real and poignant and relevant, but you just say, well, this is the important case, but it's not the legal case, and we're going to discuss the legal case, and the ethics have to be thought about somewhere else?
I'm not sure this really answers it, but my practice brings me to all parts of the world and all countries of the world, and most of the disputes are precipitated by the hunt for oil and gas. And I feel like there are some ethical issues in there for me that I tend to ignore and submerge and focus on the law. What is the law for dividing up these areas? So that may be a sort of an example. Here, I understand fully that there are ethical issues, there's environmental issues, there's national security issues, there's all manner of issues around deep seabed mining, and a lot of them are totally valid. And I think that we need to have them all in the mix of the conversation. But my focus is on the legal. This is the law. This is outside the law. I think there's value in staying inside the law. So I'm trying to set aside a lot of these other parts of this equation, which are big human societal problems, and I think we need to address them, but that's not what I'm at the moment.
That's a great place, I think, to wrap up. So, is there anything else that we haven't touched on?
I think we'll have to save it for the next one. No, I think we've covered a lot of stuff, and we'll see. Hopefully it's been helpful for you and your listeners.
Well, it's been helpful for me. I can only assume it's helpful for the people who listen to this podcast. Where do you point people who want to get more information on the issue? Are there any sources that you would point people to say, hey, if you want to know more about this, look at, here's a website, here's a book, here's a person to follow?
I mean, if you're interested in sort of the basic primer on international law in this area, I've got a webinar on the Payne Institute's website, and I can send you that link if you don't have it and put that up there. But that's just an hour-long sort of real basic. Here's what customary international law is. Here's what treaty law is. A little bit of the history that we just went through, so it might be redundant as to what we just discussed. If you want to nerd out a little bit more on some of the international law questions here, the European Journal of International Law's blog site, Evil Talk, has some good stuff on it. One of them happens to be mine, but there's another piece by Sam Robb and Toby Fisher on, I think they call it untouchable metals, and it gets to some of these sort of substantive legal issues that countries who are states parties to the convention are going to face, and their nationals are going to face if they violate their nation's obligations. I took a lot of, in the early days of April, as I was trying to get up to speed on this, I found a lot of value in a book by Joanna Dingwall, based in Scotland, and the chapter in particular on this issue of third parties, non-state parties to the convention in the arena of deep seabed mining, which is, in this case, the United States. The book is International Law and Corporate Actors in Deep Seabed Mining. It came out in 2021, so it was prescient. I think if you read the chapter on preventing unilateral deep seabed mining activities, which has a subtitle, To What Extent Does the UNCLOS Regime Constrain External Actors, again here the United States in this case, I think you'll see that he wasn't really anticipating that this would actually happen. And I think if you polled in mid-March of this year a good cross-section of public international law experts, there would be very few people who would say this is likely to happen.
Okay,
But that book and that chapter in particular, really, if you want to drill down, is a great resource.
we'll put all of these links as well as links to some of your recent articles on the show notes to this podcast. People can check it out there. Where do people follow you if they want to keep up with? Are you on social media somewhere? Would you share your opinions?
I am trying very hard to limit my social media, but I have picked LinkedIn as the place to say my piece. So if I say anything or write anything of any importance, which is a pretty rare occasion when it happens, I will let the world know through LinkedIn. And of course, I've posted there in the past. So I think if people want to look at what I've said, they can find a lot of it there.
Great. Okay, well then, Coalter Lathrop, thanks again so much for taking the time to walk me through all of this.
Thanks, Eric, for having me. I'm really happy to have done it.
And to the listeners of the podcast, as usual, if you think this podcast is worth sharing, then please share it, rate it, and review it like all podcast hosts ask you to do. It really helps me get the message out. I don't do this for any personal gain either. This is just this is just a gap that I noticed in the public conversation, so I'm trying to fill it.
Thanks for doing that, Eric.
Okay, thanks, Coalter.
I throw my arms up and to the side.